Welcome to today's program, Venmo, Bitcoin, and Beyond, the ethics of modern payment methods. I'm Ala Policastro, Director of Education and Professional Development at Beverly Hills Bar Association. And today I'm delighted to introduce our speaker, Ryan Little. Ryan is the founder of Little Legal, a law firm dedicated exclusively to legal ethics. He began his career as a bar prosecutor with the Hawaii Office of Disciplinary Counsel, where he handled matters from investigation through trial and appeal. He later joined a West Coast law firm's complex ethics group, where he advised on emerging ethics issues and represented lawyers before the State Bar of California. He serves on the board of the Association of Professional Responsibility Lawyers and on the California Association of Discipline Defense Counsel. He regularly speaks and writes on legal ethics and has been published or quoted by Bloomberg Law, Law 360, the ABA Journal, and other outlets. We're so excited to have him here with us today, so I'm going to turn it over to him.
Thanks so much, Ala. Hello, everybody, and thanks for joining today. I'm going to go ahead and share my screen, and we'll jump right in here. All right. So, this is a cart before the horse. Let's back up. Here we go. All right. So this presentation is Venmo, Bitcoin, and Beyond, the ethics of modern payment methods. As Ala said, I am Ryan Little, former state bar prosecutor for the state of Hawaii, which, yes, I promise is a real job. I also, about 2 years ago, actually 2 years ago today, this is my 2-year firm anniversary of the founding of Little Legal. We're a legal ethics firm. That's all we do. We serve lawyers in California, Hawaii, Oregon, and Alabama, which, to answer your question, why Alabama? I'm from there. And fun fact about me, I once reasonably believed I was about to be nuked. So I don't know if you all remember, in 2018, there was a nuclear missile false alarm that was sent out to residents in Hawaii through the emergency management system, HIEMA. And I received that text while doom scrolling in my bed that morning. Scariest day of my life. All right, about the firm. So about Little Legal, our mission is pretty simple: just do the right thing. But that, it's straightforward. It sounds good, but what does that mean? And doing the right thing can mean something different depending on the context, depending on the day, depending on the client. So we exist to help people navigate those sorts of gray areas that arise. What we do is generally kind of falls into 2 buckets. I call them risk management and outside general counsel. The risk management entails things like ethics consulting. Those are, it's more of a proactive side of the practice. So, I have an ethics issue and or something I want to do, and I want to make sure I don't run afoul of the rules of professional conduct or the state bar. Discipline defense, which is sort of the reactive side of things. So I've got, a matter before the California State Bar, and I want to make sure that it doesn't spiral into something worse. Please help me. We'll defend lawyers in those proceedings. And then also trust account compliance systems. This is something that we're doing a lot more of, particularly in the age of CTAP. And then finally, outside general counsel. So that is, less of an ethics risk, more of a business risk. Which we're uniquely positioned to do because the two often intersect, and we have a lot of experience looking into and under the hood of many different lawyers and law firms' practices. Who we serve is really lawyers and law firms of all types. The smallest client we would serve is a solo, and we do have some solo clients. Our largest clients have several hundred to some more than 1,000 lawyers. We serve a lot of plaintiffs' firms. We do a lot of wildfire work. Consulting work. And where we operate, again, it's California, Hawaii, Oregon, Alabama, and coming soon, New Mexico. All right, so let's jump into why are we here? Why are we talking about modern payment methods? Well, clients, they don't want to pay like it's 1995 anymore. Lawyers are often getting the question, can I Venmo you? Or do you take crypto? Or I don't use checks. And if you want to remain market competitive, that's a thing that behooves you to investigate. Is this something that you can do? How do we handle these requests from clients who've grown up in what's becoming increasingly what's called the frictionless digital economy? I could write you a check and mail it to you. Then it would take a few days to get there, and then you have to cash it with your bank, and then it takes time to clear. or I can Venmo you the money and it's ostensibly in your hands or in your possession instantly. It makes sense that lawyers who want to strike while the iron's hot, or who want to make sure that they, give their clients as many and as flexible options as possible, that they're interested in these types of payment methods. The core tension here, though, is that while modern payment methods have evolved really rapidly, ethics rules haven't really kept pace. So, and clients adopted technologies like Venmo, Zelle, Cash App, and Apple Pay. I mean, the proliferation and adoption of those technologies happens almost seemingly overnight. And the reasons for that are quite clear. People are living increasingly more cashless, and people want to be able to, have their the ability to split bills and share money between friends in a way that doesn't require transferring of paper fiat currency. The issue is that the model rules or the rules professional conduct, depending on which one we're talking about here, this is a California specific presentation. We're talking about the California rules professional conduct. They haven't really kept pace, and they were written for a world where wire transfers and checks were the primary modes of payment. And I think what's important for us to get to here, and this is sort of previewing what we're going to be talking about later, is that convenience in the case of payment methods doesn't always align with compliance. And I think this is something that bears repeating, especially as we are living in what I would call a more anti-regulatory world, where people are increasingly saying things like, well, what are they? How mad can the government get if I'm doing this thing that everybody else is doing? And the answer is State Bar can get fairly mad. So the ease of a payment method really doesn't have any bearing on whether it satisfies your professional obligations under the rules of professional conduct. And so this all matters more than you think. And the reason why is that client funds mismanagement is the number one with a bullet reason that lawyers get disbarred. Mishandling of client funds is the number one reason that lawyers lose their license. Lawyers are often, when they come to me, they often are concerned with malpractice risk, and I understand that. And it's a very normal thing to worry about. But I often tell people that the biggest risk to your career is the inability to actually apply your trade, the inability to actually have, or you're losing of the law license. And so I think it really behooves lawyers and everybody, if there is one ethics rule that everybody knows, it tends to be that you need to ensure that you handle client funds in accordance with your duties. Where this intersects with modern payment methods is that the proliferation and the diversity of these payment methods has it's become sort of a risk multiplier. Modern payment platforms have introduced many new points of failure. There's things like chargebacks, there's volatility in the case of cryptocurrency, which we're going to discuss later. There are reversals and missing audit trails that don't exist with traditional methods. And the reality is that a small mistake can have big consequences. It's a little cliche, but a single retainer deposit that's improperly deposited or tracked in the wrong way, or an untracked cryptocurrency conversion, or even an accidental public ledger entry. These are the types of things that trigger bar investigations and audits, and all those things we really want to keep our practices out of. So while modern payment methods increase the ease of commerce, they also increase regulatory risk. So the four primary pressure points that we are going to talk about today, when we're talking about peer-to-peer payments, and that's the P2P acronym that you'll see there in the top line. The four primary pressure points we're going to talk about are safekeeping risk, and that relates back to a lawyer's duties to keep funds and hold them in trust in a manner that's consistent with the lawyer's obligations under Rule 1.15. Also, Rule 1.5, which governs a lawyer's or discusses a lawyer's duty to refrain from charging an unconscionable fee. I think there's a valid question about how is this rule implicated when the lawyer is paid with something like a volatile cryptocurrency. Then Rule 1.8.1, which is the California Rule of Professional Conduct that discusses what happens when a lawyer is paid in something that behaves more like a commodity than a stable currency. I think that's also germane to the cryptocurrency conversation. And finally, the confidentiality and competence angle. Um, One of the biggest risks that I think goes untalked about um, when we're discussing modern payment risk is confidentiality risk. And we're going to talk more about this later, but I think all of these three pressure points or four pressure points really are almost subsumed in the idea of competence. And Rule 1.1 of the Rules of Professional Conduct imposes upon lawyers a duty to provide competent representation, which includes, per the rule, the ability or the duty to stay abreast of changes in technology. And I think that duty is strongly implicated here when we're talking about modern payment methods. And this is especially true, and I don't mean to pick on them, but this is especially true for veteran practitioners who've been practicing since well before these payment methods proliferated and who may not have sort of the digital native facility that younger practitioners might have. So let's talk about the P2P payment landscape. So what are P2P payments? This P2P is an acronym, stands for peer-to-peer. And peer-to-peer payment platforms allow for essentially instant money transfers between individuals using bank accounts or stored balances. These, for somebody who was, they probably, I would say they really started to proliferate around the 2014 to 2016, maybe 2015 era. And they took off quite quickly. And for somebody like me who was in their mid 20s at that time, they were a bit of a godsend for people who are going out and splitting dinner or buying rounds of drinks, as the case may be, or even splitting an Uber or something like that. The 900-pound gorilla in the peer-to-peer payments arena is Venmo. The first one was PayPal, and that came about during what I call the eBay era. I don't know what anybody used PayPal for prior to 2005, except for paying for eBay purchases. That was all that I used it for. PayPal then bought the nascent startup Venmo. Venmo is now the clear market dominant player in that arena. So much so that when people don't even say, "Can I send you money?" they say, "Can I Venmo you?" Zelle is a more recent player. It is a little bit different in how it's architected than Venmo, and the architectural differences in how these two work is really meaningful. And we're going to talk about the structure and where they differ a little bit later. Uh, Interestingly, Zelle is operated directly by a consortium of banks, the participating banks. So Venmo is owned by PayPal. Zelle is operated by a consortium of banks. Cash App is probably the smaller player. It's owned by Square. Has a little bit broader of a financial feature set than Venmo and Zelle. It has the ability to buy cryptocurrency and things like that. It's operating a little bit more like almost like a bank replacement than Venmo and Zelle are. And then Apple Pay, which, as you can probably imagine, is owned by Apple. It's actually powered by Green Dot, which I don't know if any of you have ever purchased a money card from Walmart, but those are also powered by Green Dot. These are the money in Apple Pay is stored in FDIC insured pooled accounts. And the holding of these monies, I know I'm talking about how they're stored. This is going to come up later when we're talking about ethics risk. So again, why clients love these types of platforms is that they offer instant confirmation, no check writing, no wire fees, and a familiar, easy to use interface. So basically, it makes paying your lawyer as easy as splitting dinner. The problem here, again, is that the ease of use is engineered for consumers. Your obligations as the lawyer are those of the fiduciary, and we need to make sure that we don't lose sight of that. So let's talk about from a mechanical level, how does Venmo actually work? And I promise that we're going somewhere with this. I'm not just boring. I hope I'm not just boring people with technical details. So here's how Venmo actually works. With Venmo, you have an app. Many of you probably have it on your phone. When you elect to, that app whenever you create a user account on Venmo, it creates a wallet. To load your wallet with money, you have to debit funds from typically from a bank account. At that point, your Venmo wallet has money. But the app, the funds in your Venmo account exist as a balance on the app. It exists as a balance on the app. What I mean by that is the funds are not held in an FDIC insured bank account. They're not held in an account that you can't go down to Wells Fargo and say, hey, I want to take some money out of my Venmo account. They are held by the company. Uh, and at the point when you decide to send money to someone via Venmo, the money is the balance, your balance is debited and their balance is credited in the appropriate amount. So you can withdraw that money, but most people don't. Most of the time the money is stored on the app. So the Venmo money or money arrives in your Venmo balance. It's then stored in the other party's Venmo account. And then you can either, spend with the Venmo or withdraw to your bank. An important feature about Venmo and sort of one of the things that made it a selling point early on is that it has a social feed. So you can see all the things, unless somebody makes their feed private, you can see all the things, the people they're sending money to and what they're sending money for. And this has, if you are interested in a little internet deep dive later on, take a look at all the famous people who've been brought down or embarrassed by their Venmo social feed transfers. It's actually fairly funny. Um, the important thing, though, that I want to talk about with Venmo, I want to reemphasize the money is stored on the app's platform. So you're sending money you're debiting money from your bank account. It's going to Venmo or to Venmo's parent company, PayPal. They are then holding it for you. And that's really important whenever we're talking about accepting money as a fiduciary under Rule 1.15. A Venmo wallet is not what it is not. It's not a bank account. Like I said, it's not FDIC insured. It's also technically not IOLTA compliant. Another feature about Venmo that I think is really, really relevant, especially if we're talking about lawyers who are interested in taking money for legal services via Venmo, is that payments via Venmo can be reversed or disputed. Why is that germane? Well, what happens if you accept money into an IOLTA account or a Venmo account that you're using as a de facto IOLTA? If you're doing that, please see me afterward. This is something that we need to fix. And the client, but what if you're doing that and the client reverses or disputes a charge and Venmo agrees with them and debits your account for money that you've maybe already withdrawn? Well, at that point, then the withdrawal would be coming from another client's money. And that would be arguably misappropriation that you would sort of facilitate it. And I think that's a really, really important when we're talking about how these apps store their money. One of the most important things about an IOLTA is that it's sort of sacrosanct. An IOLTA, for those of us who may not be hip to the jive of ethics lingo, an IOLTA is interest on lawyer's trust account, so basically a client trust account. Those accounts are supposed to be sacrosanct. They're supposed to be shielded from creditors. And they are the disputing of charges or the reversal of charges from an IOLTA account is theoretically not supposed to happen. Your Venmo account can also be frozen. I think that's really important when we're talking about large balances, especially if we're slushing them, multiple clients' funds on Venmo. That's really, really important. Again, a third consideration is that transactions may be public. The default for Venmo is to show everybody who you're sending and receiving money from. If people start if they see that, John Q client is sending, Lindsay Lawyer money multiple times a month, that would be arguably somebody could deduce that this person is paying money. And imagine, the client confidentiality concerns if it's something like, say you're the preeminent divorce lawyer or the preeminent prenup lawyer in a certain area. And you're sort of by default, if people can tell where the money is flowing to and from, they can tell that you are providing legal services to this person. If they look you up and they put two and two together, that's arguably a breach of confidentiality under Rule 1.6. Finally, The platform with Venmo, the platform controls access, not you. You don't get to decide whether you have access to your Venmo account. The platform does. That is extremely important whenever we're talking about how we're going to manage and hold client funds. That's something that we just simply we can't avoid that issue. I'm going to pause for a second and see if we have any chats here. Any Q&A. I don't see any. Suzanne, do we have any Q&A? No,
At
none
this
of the.
time, no.
Okay, great. All right. I assume that means I'm covering it so thoroughly that nobody could possibly have questions. All right. Well, we'll continue on. So we talked about Venmo. Let's talk about Zelle. Zelle is a more recent player to the market than Venmo, and I don't think it's quite as widely adopted, but I think that it's it's much safer from a compliance standpoint. So Zelle works a little differently than Venmo. Whereas, and I know I promise we're almost done with the mechanics of these two payment systems, but whereas Venmo holds the balance of funds on the app, Zelle is a direct bank to bank transfer. It's essentially the middleman facilitating an ACH transaction. So in a Zelle transaction, you inform your bank that you want to send money to someone. They tell the other bank, okay, hey, we're going to send money to you from this account to this other account that's at your bank. And the receiving bank says, okay, they credit the balance, the incoming balance, and the sending bank debits the outgoing balance. Where this is meaningfully different than Venmo is that there's no intermediate wallet. Like I said, in Venmo, your money is stored on the platform. There's a Venmo wallet that you have to refill and that you send and receive money from. With Zelle, the money goes directly from your account to the recipient's account. A convenient feature of Zelle is that it's built into banking apps and that it's essentially like Venmo, it offers basically nearly instant settlement. So I just want to, this is going to be the last peer-to-peer payment slide until we get into crypto. This is going to be the last one that talks about how the mechanics of these platforms actually work. And I think this one's pretty useful. I created this. I wanted you all to see how, sort of a comparison of these different apps to understand, where the potential risk points are. The reason why if I'm recommending someone which app to use for peer-to-peer, I'm telling them Zelle. I have heard of lawyers having difficulty connecting Zelle to their IOLTA accounts, but I don't think that I think that's a problem that was somewhat limited to its earlier rollout. I think it's much easier now. Oh, we have a question. I assume the decision to accept Venmo and Zelle payments involves a different analysis if the payment is just a payment for services already rendered versus a retainer or other trust payment. That's exactly right. Yes. This is, and we're gonna talk about that a little bit later on. I've got a best practices slide that's going to get into exactly that. Thank you for that question. So to the point about the different platforms, I think Zelle is by far the safest. Another important feature about Zelle, I don't know if it's on the slide, you can't reverse a transaction in Zelle. There's no undoing it. The way that the banking consortium that runs it has tried, I think it's called warning systems, if anybody wants to look them up. The way that warning systems or early warning systems, the way early warning systems runs this app is that it's meant to be essentially like a wire transfer. I mean, again, it's an ACH, so it's irreversible. It's not challengeable. This is supposed to be digital cash exchanging, digital hands. So if when we're talking about Zelle, I think the risk is much lower from a risk standpoint or an ethics risk standpoint. So let's see, what is peer-to-peer missing? Peer-to-peer, the problem with peer-to-peer in some people, and this is for people, and I promise that lawyers like this exist, and if you're not one of the lawyers who's doing this, then I apologize for making you sit through this. Peer-to-peer systems should not be used as an IOLTA substitute. There's no inherent structure. There's no inherent structure, no inherent IOLTA protections. There's no mechanism necessarily to flag commingled funds. I my slide says they're naturally or structurally incompatible with trust accounting requirements, and that is true to the extent that there are lawyers, again, and this may sound unbelievable, but it is true. There are lawyers who are using their Venmo as an IOLTA, or they're using some third-party platform as their actual IOLTA. The other issue that I want to flag is that sometimes when lawyers are using Venmo, especially that is a platform that is designed for consumers, not fiduciaries. I'm a big fan of use the right tool for the right job. So using Venmo, to split a cab ride is one thing, but applying it to a $50,000 retainer creates sort of a serious mismatch between the structure of what that program was intended to do and the lawyer's professional obligations under Rule 1.15. Let's see, and this is another slide on the same idea. So what Rule 1.15 requires is a separate trust account, an IOLTA account, or a client-specific trust account. There's no commingling of client and firm funds allowed, except for the personal funds allotted for under Rule 1.15. Rule 1.15 requires a complete ledger or sub-account ledger for each client matter, and prompt accounting and delivery of funds. Peer-to-peer apps generally provide, it's mostly on-app wallet-based storage, Zelle being the exception. Commingled or client funds and operating funds if you're using a single account, client funds and operating funds are generally commingled unless you're able to link something to your IOLTA, unless you're able to link one of these accounts directly to your IOLTA. Another thing that I think is, and I've flagged this before, but another thing that I think is really important to consider is the terms of service of these platforms. Most peer-to-peer platforms are generally fairly unfavorable to fiduciaries. And that's because of chargeback risk and reversal risk and freeze risk. I've heard horror stories of certain banks freezing accounts, but they don't have quite, at least banks are heavily regulated in that arena. I don't know that there's quite the same amount of regulation when we're talking about peer-to-peer payment systems. So, bottom line, a peer-to-peer app is not a trust account and can't substitute for one under any circumstances. And we have a comment from somebody watching today who says that, just FYI, I tried to have a client send money to my B of A IOLTA a few weeks ago and was expressly told that it's impossible. That aligns with what I've heard previously from other banks. But I think it might be a bank-to-bank thing, and it might even be a bank manager to bank manager, depending on what people who you're talking to on a given day. The reality is that most banks, in my experience, most bank employees don't know very much about trust accounting. They don't know very much about IOLTA accounting or IOLTA accounts generally. And so it's entirely possible that, if you ask someone whether something is possible, they'll tell you yes, and if you ask another person, they'll tell you no. Let's see, we're gonna keep going here. I want to talk about quickly the confidentiality risk. Again, I discussed this earlier. Venmo's social feed is public by default. So if you're the type of person that's using Venmo and you have your social feed public, make sure that you make it private. And that's something to do post haste. If you haven't taken steps to make sure that your transaction history is confidential, then conceivably anyone who has a connection to you can see who's paying you money and what they're paying you money for. But there's also, beyond that, there's metadata concerns. There's also questions about whether screenshots of accounts or account statements on Venmo are discoverable in litigation. But there's, especially when we're talking about, a peer-to-peer payment app as opposed to a proper IOLTA account. So I got some ideas, sort of best practices here when we're talking peer-to-peer payments. I think there's a couple of different approaches you could take here. The first is to use Zelle only. Oh, we have another question. For filing fees or other third-party expenses advanced by the law firm on behalf of the client, may the client reimburse the firm via Zelle or Venmo? I would say that is probably a yes. I think it's important that if you're going to do that, though, you want to make sure again that that you have the guardrails in place to ensure confidentiality. And you also want to make sure that you're properly tracking those expenses in your monthly IOLTA reconciliations. Sorry, a brief water break. All right, so a couple of ideas on best practices for using peer-to-peer payments. The first one is to use Zelle only. I think Zelle is the cleanest because of its bank-to-bank transfer model. It makes it's the clear, what I call the clear compliance pick. You want to make sure that you take pains to avoid commingling. Make sure that if you're accepting retainers via Zelle, that the retainers go straight into an IOLTA account that's linked to Zelle. Do not accept, payment for past legal services into an IOLTA. That's commingling. And also make sure that you don't accept payments or deposits for legal services, so retainer payments into an operating account, because that would be misappropriation per se, which that can get you into serious trouble with the bar. So that's one model. The second model is you could do Venmo, Cash App, or Apple Pay, or Apple Cash, I should say, for earned fees only. So at that point, peer-to-peer payment is used exclusively for fees that are already earned and belong in the operating account. I think there is less of a commingling misappropriation concern there. In this model, you're never using it to receive advanced fees or retainers or other funds that are being held on behalf of a client or third person. Instead, all you're doing here is basically collecting money already owed or money already earned. Again, though, you want to make sure that you have your social feeds turned off. And that's the final block there in the bottom right. Many, if not most, peer-to-peer apps have the social element, so ensure that you turn off all such features before accepting payments, and also advise your clients to do the same. We don't want, your feed may not be public, but theirs might be. You want to make sure that it's not that it's invisible on both sides. All right, we're going to run through this one really quickly. This is credit cards. It's not so much of a modern payment issue. Credit cards have been around a little while, one might say. The reason why I want to talk about it, though, is this is a question that's come up a lot more about the processor angle of credit cards. So the primary ones that I see people using are LawPay, Stripe, and Square. And what they really add to the picture, this is, they're the middleman. They're facilitating the transaction. Not all processors are built to understand and protect trust accounting obligations. So in the important, I guess, detail is, a processor typically will debit the processing fee from the account to which from the overall amount of money that they're going to credit the account involved. So to say that in a more straightforward way, if a client or if a customer buys a $1,000 item at a store on their credit card, the store will typically take $1,000 net of processing fees, and so they're not getting they're not going to get the full 1,000. They're going to get 1,000 minus whatever it is, 2.5 to 3.5% processing fee. This does not really work in lawyer trust accounting. So imagine a situation where your client pays a $5,000 retainer by credit card. Your processor is going to take 2.9%. And how do you structure this transaction? So I think there's a few ways to do this. The way that you can't, that most, I would say you definitely should not do it, is by letting the processor take the payment right off the top, because the client is making an agreement with you that that they're going to have $5,000 in trust for you or for to retain your legal services. If this fee is 145 bucks on 5,000, if it's taken right off the top, then that means they would have $4,855 from the jump. So they're not getting the full benefit of their 5,000. And this was one of the reasons why for a really long time, many lawyers wouldn't take credit cards because there was a question about how do we do this in a way that's compliant. LawPay is really the vendor that kind of helps solve this. And what they do is they debit your operating account for processing fees. So I've got a couple of options here, different ways that you can structure it. You could take the fee directly from your operating account, from operating funds. That's the LawPay way. You could also theoretically deposit $145 of your own money into the IOLTA if the processor insists on taking it from the IOLTA. But this runs into a similar problem that we discussed in the peer-to-peer payments issue, where if you're doing this model, you are essentially opening up your IOLTA to a creditor. That violates that sort of law of sacrosanctness of the IOLTA account. You can also pass the fee on to the client, so you can have them, you can have them charge. You can structure the deal in a way that allows for the client to pay the fee rather than the firm, and that's going to happen on a vendor specific level. How you're actually going to have to structure that. My recommendation: there's lots of good payment processors out there. I tell my clients keep it simple. Use LawPay. It's the biggest one for a reason. So again, best practices here, use legal specific platforms, make sure you separate earned fees and unearned fees, reconcile monthly. That's a big one. That's just a general ethics risk management tip. Reconcile your trust accounts monthly. There's been a lot of lawyers and law firms that I've represented that could have saved themselves a ton of heartache if they'd have caught small errors early on. If you're not reconciling your books, doing a proper three-way reconciliation on a monthly basis, or don't know what that term means, feel free to reach out because that is sort of the essence of doing this the right way. I would also say for just in your SOPs, if you're the type of if you're a firm that employs a clerical staff or an accounting staff, make sure that you write your policy down, your payment platform policy down, what platforms are authorized, whether the firm is absorbing the fees, and how the reconciliations are performed. Somebody says, have you heard of any specific concerns with payment processing through Clio? I have not. And to my understanding, Clio, I want to say that Clio might own LawPay. If that's the case, then I assume that they're just using Clio payments is probably just running through LawPay. So I haven't heard of people using or any concerns with people using or processing payments through Clio. I will tell you, I have heard of people who are doing their trust account reconciliations with Clio as their primary data set, and where I have seen situations where that runs into issues, and that's a that's a talk for another time. So in our remaining minutes, I want to talk about cryptocurrency. This is an interesting one. Crypto is it's sort of been a hot-ish topic. It goes from medium hot to blazing hot, seemingly every few years. At this point, we're probably in the medium hot point of the cycle. But it's interesting because it's called cryptocurrency, but it's not transferred through banks. It moves to what are called blockchain networks. So a blockchain is basically a public ledger. If you want to see what one looks like, I think blockchain.com will show you one. You can see user IDs, but the user IDs are not anything discernible. They're not, Ryan Little, ethics lawyer. They say it's a random string of letters and numbers that is theoretically only known to the account owner or the user of that account or of that particular ID. It settles in minutes. It's also irreversible. And there's really no intermediary. So blockchain, the way these transactions are facilitated is actually algorithmic. If you've been following the AI, the original, currently everybody's building data centers to accommodate AI demand. Previously, we were all building AI, or we're building data centers to accommodate crypto demand. Essentially, the way these transactions are facilitated is through a distributed network of computers, various people all over the world, including, some people in their own homes, some people are like sort of tethering hundreds or thousands or tens of thousands of computers together to solve algorithms or to solve problems posed to them by algorithms. These algorithms, once solved, will uncover what are known as blocks, and you'll get, or will uncover. I'm sorry, these algorithms, once solved, will release new Bitcoin or cryptocurrency to people, and some of these currencies are worth quite a bit of money. Where this ties into the facilitation of transactions is that this distributed network of computers is the one that's validating. So in the same way that with Zelle, you have one bank that says, hey, we want to send money to this person at this account. We verify that the money's there. And then they talk with the other bank. The bank says, great, we'll receive the money. And then the transaction is recorded privately. Cryptocurrency does that, but it uses this distributed network of computers to validate that the transaction can go through. And what I mean by that is you have a network of computers that validates that yes, the sender has the appropriate amount of currency in their account. The other network says, okay, this other account that they want to send money to exists, and then they confirm the transaction, which then goes on the blockchain. The issue with cryptocurrency is that it does not necessarily behave like a currency. It behaves a lot more like a security. It's not something. There's no bank involved. There's no central authority. There's no FDIC insurance. Um, it's some people like to think of as digital cash, but that's not really quite an apt description. I think a better mental model is that crypto is digital property with monetary characteristics. So it's very volatile. I don't know if people have noticed how much cryptocurrency swings in price. Bitcoin is by far the largest of all the cryptocurrencies in the world, the most popular. I think currently it's around 70,000, but a few months ago it was almost 140,000 per Bitcoin. Cash, at least US cash, at least at this time, does not have that amount of volatility in it. So it's behaving more like a speculative investment than it is a currency. And this comes into play whenever we start to consider how do we then think of it for the purposes of securing the payment or securing the rendition of legal services. So COPRAC, which is the esteemed panel of ethics lawyers that comes up with formal ethics opinions for California, issued an interim or has published an interim formal opinion, which is not does not have has not been adopted to my knowledge, but it indicates that California should treat cryptocurrency as property and not legal tender. This does make a huge difference in how we think about it from a compliance standpoint. Because it's not legal tender, that means that it triggers different rules or different compliance obligations when we're talking about transacting in it with clients, rather than it falling under Rule 1.15 only and Rule 1.5 only. It also implicates Rule 1.8.1. That's the rule governing entering into business transactions with a client. Importantly, crypto cannot be deposited into an IOLTA. IOLTAs literally cannot accept crypto. I mean, IOLTAs are set up to accept cash, not Bitcoin. It's impossible to tell your bank, hey, I want to hold Bitcoin in my IOLTA. And so because of that, because it's behaving more like a security, it's properties, and it also could arguably, and I'm sure there's a tax lawyer who's watching right now who is either thinking is thinking what I'm about to say, or is about to say that I'm wrong, but it presumably, because it's property, it has different accounting, tax, and safekeeping rules that must apply. It might create the transferring of crypto might trigger a taxable event on the part of both the sender and the receiver. And when we're considering capital gains and things like that on how crypto works, those considerations are really important. So there's been several states who've issued ethics opinions on crypto, and I would say at this point the emerging consensus seems to be that it's more of a property or security classification than it is a currency classification. So as I talked about earlier, crypto is an extremely volatile asset. It's dropped just more than 50% within a single calendar year. Or Bitcoin has dropped more than 50% in a single calendar year. That's this year. Ethereum is also, which is probably the number two in terms of market share, has swung 20% in a week. Where this gets sticky is that a retainer that's received in crypto today may be worth dramatically less or dramatically more tomorrow. And that's before you've ever earned a dollar of it. Where this matters is that if you and a client agree to a certain amount, a certain retainer that the client wants to pay in Bitcoin, say a $70,000 retainer, and the client pays you in one Bitcoin right now, which roughly, again, about 70,000 per coin, and Bitcoin spikes tomorrow, say it goes back to 140,000. Who bears that risk of that inflated valuation? Because now what the client gave you yesterday is worth double today. Is this does the fact that does your obligation as fiduciary allow you to inure that benefit to yourself, or do you have a duty to, split it in half and give back half to your client? Alternatively, what happens if if you require that $70,000 retainer or say you require $140,000 retainer and Bitcoin drops by 50% overnight? And all of a sudden now that $140,000 retainer is worth 70 grand. Who bears that risk? And I think there's almost the there with given the volatility risk here, the inflationary and deflationary risk, I think that there's a temptation for a lot of lawyers to think of to contemplate the idea of accepting retainer deposits in crypto as something like contingency fee practice, where, well, I might get half, but I might also get, I might get half of what I'm thinking I'll get, but I also might get double what I think I'm going to get. And so I'll take the bad days will be canceled out by the good days, and so on and so forth. And the fact that I'm going to get 70,000 or 35,000 sometimes, but I'm also going to get 140,000 other times, I should be able to, if I have that risk tolerance, I should be able to accept it. But I think that what bears considering is that courts and state bars are probably unlikely to be sympathetic to a lawyer where a retainer deposit is suddenly worth 50% less or 50% more. What happens if the retainer is suddenly worth 10,000% more than it was? What happens if a client tells you, I want to pay you in Dogecoin circa 2018, and all of a sudden you're now a multi-millionaire because the client gave you gave you $100 worth of Dogecoin the night before it takes off. Let's see. We have a question. I only do transactional work. Along those lines, how does this impact flat fee agreements? For example, let's say I agree to do all the work for one Bitcoin. Along similar lines, what if I agree to do all the work for a 5% share of the company? If those amounts never touch my IOTA, what do the ethics rules say? So we're actually going to get into that first question about if you agree to do all the work for one Bitcoin. And I think the Kokrak opinion talks about that. What if I agree to do all the work for a 5% share of the company? That definitely triggers rule 1.8.5. That's probably a little bit longer of an answer than what I have remaining time to get into. But we will definitely touch on the first question in a moment. What if the payment is in Bitcoin and not dollars? One Bitcoin for 1 hour. Well, first of all, if you're charging one Bitcoin for 1 hour, you're the most expensive lawyer I've ever heard of. But what if a client wants to pay in euros or another currency? I think that's a valid question, and I think that's the argument. What if they want to pay in, Zimbabwean dollars, which are highly volatile? Are we saying at that point we can't treat this like a currency? And I think that's the counterpoint to the idea that this is a property, that based just purely on volatility, this is a property, because there are volatile currencies. And if that's what they've got if that's the money that is the currency in which their wealth is denominated, and they elect to pay you in that, and you elect to accept it, why shouldn't two consenting parties be able to make that transaction happen? And so I think the volatility and the risk question here really leads to the final question, which is, do you convert or do you not convert whenever we're talking about Bitcoin? So converting to fiat currency limits volatility risk, but again, are there tax consequences for the client when we're talking about things like capital gains? Um, this entire transaction implicates Rule 1.8.1, the business transaction rule. I think I said 1.8.5 a moment ago. I apologize. When does Rule 1.8.1 apply? So that's the rule that governs business transactions between lawyers and a client. What it says is that it applies anytime the lawyers and a clients that a lawyer and a client has an adverse or diverging financial interest in a transaction. So to the question about what if I agree to do all the work for a 5% share of the company, the terms, what is required under Rule 1.8.1? I see there's a typo there because I originally gave this presentation in a state that doesn't have Rule 1.8.1. The terms of the agreement must be fair and reasonable. The terms in the lawyer's role must be fully disclosed in writing. And the client must either be represented by independent counsel or be advised in writing to seek independent counsel and given a reasonable opportunity. I think the client must also give informed written consent as to the terms and the lawyer's role. Informed written consent in California, that's a defined term of art, and it means a full and free disclosure that is such that you're making the client aware of the various risks and the various considerations they need to know about in order to make a reasoned decision. And under Rule 1.8.1, it actually goes a step further and says that the disclosure must be full enough that the client should be reasonably expected to understand the facts and circumstances surrounding the transaction. So basically, the rule of thumb that I use with my clients and that I use with courts whenever I do expert witness work is that the fuller and freer and plainer the disclosure, the more effective the waiver is. And if you're couching everything in legalese and sort of burying important terms, courts are much more likely to find those disclosures ineffective. Another problem created by crypto here is the trust accounting problem. Where do you put it? You can't put it in your IOLTA, so what do you do with it? And I think there's really two options. Option one is you could convert it to US dollars at the time of receipt and deposit that into your IOLTA account. The other option is you can hold it in a separate crypto wallet. If you don't know what a separate crypto wallet, if you don't know what that term means, I would encourage you that I would counsel you that accepting crypto is probably not a smart decision for your practice. Crypto wallets are there's basically two ways you can manage crypto or hold cryptocurrency. The first is what's called hot storage. So that is on, say, a website or an exchange, and you've probably seen those types of, you've probably seen several of the companies that do that. I mean, there's crypto.com, there's Binance, there's Kraken, there's all sorts of platforms that allow for this. These are a security risk, though, because again, crypto transactions are irreversible and they're also untraceable. And if you want to know if there's a real risk of that, of the real risk here is that the platforms get hacked. And if you want to know if that's actually possible, you can Google the Mt. Gox bankruptcy. That's MTGOX, Mt. Gox. It's a Japanese cryptocurrency exchange that was hacked in 2014, I believe. And the hackers made off with $200 million of crypto in 2014 valuation. So that's quite a bit of money. So there's three crypto payment structures that I think you could really use. You could, I think the way that we structure these types of transactions and payment for cryptocurrency, I think it matters. And how you structure the fee determines your exposure under the rules. So the first is for payment after the fact. This is a situation where the fee is nominated in US dollars and payment in crypto is optional. So the client owes, say $10,000, and they may pay in cash or crypto, or cash or crypto equivalent at the time of payment. The risk there is low and the fee is fixed in US dollars. The crypto is really just the means of delivery. You can also, if you're going to demand payment in crypto, so payment after the fact in crypto. So you're saying, rather than you owe me $10,000 to go to the question we had a moment ago, you owe me But instead of saying, let's use actual valuations, instead of saying you owe me $70,000, you owe me one Bitcoin. At that point, because it's sort of a volatile floating obligation in terms of valuation, you probably are treading into more of a 1.8.1 scenario. If you just say you owe me 70 grand, the client says, well, would you take one Bitcoin? You're probably outside of the rule 1.8.1 business transactions murkiness, and you can probably just accept that straight up. Um, the second payment structure that I want to talk about is where you're getting paid before the fact. So that's where the fee is set in US dollars and received in crypto at market rate. I think this is more risk because of the conversion timing, the volatility between that may occur between the time of invoice and the time of payment. So I think you have a potential 1.8 or 1.8.1 issue right from the jump there. And I would say you want to document the conversion rate used in that scenario. If we are getting into, and this is the third one we talked about, where the fee is denominated in crypto, where you say you owe me zero point 0.5 Bitcoin. I think that this is in many ways the highest where this is where you really want to be looking out for Rule 1.8.1 issues. So we're going to talk about holding crypto in trust. So it's possible. When I say hold in trust, I don't mean an IOTA. I mean hold it in trust as in terms of safekeeping obligations under Rule 1.15. It's possible, but it's risky. So there's a separate wallet must be required or is required for each client's cryptocurrency transactions. If you don't know what that means, it's probably best to stay away from it. Even though we're holding funds in a non-IOTA account, we still probably have a duty to avoid commingling. So you want to make sure that you have a separate wallet, that it's labeled. You also want to make sure that you have structures and safeguards in place to ensure that you don't misplace the wallet or lose it. You want to make sure that you maintain a detailed record of transactions, the proper security protocols in place for accessing the funds, that you have people's seed phrases stored. Seed phrases are basically recovery to break it down in most simple terms. It's like a recovery phrase that you can use to have access to crypto if you lose access to a wallet. You also want to make sure that you have the client's written authorization. There's a final one that another point I want to talk about is confidentiality risk on the blockchain. The myth is that crypto is anonymous. That's not entirely true. It's pseudo-anonymous. It's technically, if you look at the users, the wallet IDs for the people who are sending and receiving money, it doesn't identify the person by name, but with a little bit of detective work, and especially now, I think with AI, which is able to sift through large volumes of data pretty instantly, you have to make sure that you've taken the steps to ensure that this public ledger, the public ledger, meaning that the record of every Bitcoin transaction since the very first one way back in the mid 2000s that's taken place, all of those are public. Every ID or every wallet that's ever sent or received money is visible on the blockchain. And you need to make sure that you take pains to ensure that your wallets and your clients' wallets are not easily discoverable. So again, the broader point here is if there's a question over competence, over whether we understand how this stuff works, I think you either need to hire somebody that does or avoid taking it. I have been using cryptocurrency for many years. I bought my first Bitcoin way back in 2013, and it was stolen in the Mt. Gox heist. That's how I know about it. I would even have some reservations about accepting legal fees in crypto. So we're going to kind of put a bow on it as we're coming to the end here. But before you accept the new payment method, you need to understand where funds held, who controls them, can you account for them, and what happens if something goes wrong. And again, just to hammer this home, if you can't explain the payment method to the state bar, don't use it. I think this is what I would call the most practical filter for every payment method decision you're going to make. Apply it before you accept the first payment and not after a grievance or a complaint is filed. So finally, point of self-reflection. So take a moment. I just encourage everybody to take a moment to reflect on your current practice. And the questions here are, designed to give you to kind of help surface things, surface the areas where your risks are. So, what payment methods are you currently using? Where are you most uncomfortable in terms of how your payment method systems or payment systems are structured? Are you secure in your trust account reconciliation? Do you have fee agreements that call for or allow payment in crypto? Do you like your processor? Do you trust that they're doing things the right ways? You have knowledge gaps in your staff. And then I think the last question is, what would you change this week? What's one practical step that you could take? So a written policy or a platform audit or one staff conversation, because each of those things is really much more valuable. Taking concrete steps today is much more valuable than coming up with a beautiful, comprehensive plan that actually never gets started. So I would just encourage everybody to ask themselves the question, well, okay, given everything that we've talked about today, what is my first action? If anybody has questions, I've got my email here. Feel free to reach out via email. You can also call me at the number there. Other than that, I'm happy to stick around for a moment to talk about questions that anybody might have if we want to do those offline or online.
Alrighty, this concludes today's presentation. Thank you so much, Ryan, for an excellent presentation, and thank you so much to our audience. Have a great day, everybody.